of you Ethicuties and the 40% of you who have still not subscribed to the Ethicsverse, welcome to the coolest place to be every Thursday at noon Eastern, and really every Tuesday at noon Eastern also. We got a phenomenal treat for you today. We're going to be talking about lessons and insights from real cases. So we're going to be going through incident response at every single scale. So from the first report to the final resolution, we have an august panel of phenomenal, extremely smart people, and we're going to be talking about real cases, lessons learned from those cases, what decisions worked, what things didn't work, what kind of mistakes you should avoid, and how to better calibrate your response to incidents in this complex world that we're facing. So we're going to talk about when to bring in outside counsel, how to protect the investigation from legal challenge, and what compliance officers need to know about managing incidents before they become crises. So as we get started here, let's get a massive round of applause to the Dykema team. We got the emergency incident response experts on here and our good friends, Scott. And as we get started, I'm going to run through a couple of announcements. We got a lot of cool stuff coming up, so drop that LinkedIn URL in the chat. Your network is your net worth. Neither are big enough, so go ahead and expand it and take advantage of this unique opportunity, this unique asset that we all have at our fingertips in this highly collegial industry that we're a part of. If you're not taking advantage of those things and building that network out, you're going to be reinventing a lot of wheels. And as we always say, nobody's tombstone says they were great at reinventing wheels, okay? We got a lot of cool stuff coming up in the next couple of weeks. We're really doubling down and pushing out more of these types of sessions that you are asking for. So next Tuesday, we have the one and only Reed Blackman coming. He's launched this new, it's on his book launch day. So we're gonna be giving away a ton of his new books, The Ethical Nightmare Challenge, How to Avoid the Worst of AI. He is an expert in helping organizations set up AI frameworks to mitigate risk. Remember, what got us here is not going to get us there. There's a huge opportunity for us to add more value to our organizations and help our organizations see around the curve, but it's going to take us engaging in some different ways. So we're continually trying to share more frameworks that are immediately applicable. There were so many questions in our benchmark report session that we did with the one and only Ellen Hunt that we're going to do a special follow-up session next Thursday where we're going to do a deep, we're going to do a deep dive on the benchmark report. We're going to be answering, we've aggregated a bunch of questions that have come through DMs that were in that session. So we're going to be answering those kinds of questions. And the 30th, we're going to be talking about how investigations go wrong, avoiding critical errors in the space. We have our healthcare benchmark report, the one and only healthcare benchmark report in the industry. We're going to be talking about metrics and patterns on the 5th. We got a bunch of great stuff coming up. So block off your Tuesdays and Thursdays because you're not going to want to miss it. If nothing else, block out May 12th, okay, 5/12, where you're going to get a first look at Policy Plus. This is our new policy management, AI-driven policy management platform. Things at Ethico go little by little, then all at once. We get a lot of really cool stuff coming out. We spent a lot of time in the lab over the last year thinking about what's really going to help move the needle for the cash-strapped, overloaded ethics and compliance teams out there, and we're going to help push that forward. So if you're here for credits, this is the place to be, whether it's SHRM, CCB, or HRCI. We got some credits for you, and we're giving away our good friend Christian Hunt's book, Humanizing Rules. This is still flying off the shelves. If you missed our benchmark report, hit that in the console. You should download that. People love this benchmark report. They say it's the best benchmark report they've ever seen, not even my own words, okay? So the big story from the benchmark report is that trust is down. Fully anonymized reports have skyrocketed, but reporting rates are up. So that's a massive opportunity for us to build more trust in our organizations and really apply that investigative equity across our investigative process. If you're interested in participating in our beta for our other new platform that's coming out, which is the AI first third-party risk management platform, which is getting phenomenal feedback. This thing is absolutely unreal. This can take onboarding from 2 weeks or 2 months down to 2 weeks. Too long, 2 months is too long, okay? So we want to boil that down, and the whole premise here is that AI makes the decisions. You can see there's no black box AI. Your data is not training any models, and you can control where the human is in the loop for the various different sort of tiers of third parties that you need to manage. So we are getting toward the end of our beta here. We've got a bunch of people. We got a couple people that are on it. We have a bunch of people that we're having conversations with. So if you're interested in seeing this thing live and seeing how this might, be a benefit to your department, drop a 1 in the chat or go ahead and take a picture of this QR code and fill out that form, and we'll be in touch with you in the next week or so. We had a recent session on Ethico University talking about disclosures, and that we reframe disclosures not just as conflicts of interest, but it's any piece of risk intelligence that a stakeholder in our organization wants to share with us. We talked about a bunch of different use cases. And so if you're not doing everything you can to get more of that risk intelligence in, then you're leaving a lot of potential impact on the table. So I encourage you to check that out. If you would like to learn about our disclosure platform, then go to our brand new website and schedule a demo. And if nothing else, check it out on our YouTube channel. With that, I'm going to pass this over to Scott to tell us a little bit about Dykema. If you've never been on the Ethicsverse, then maybe you don't know who these guys are, but these guys are absolutely phenomenal. We've had them on Ethicsverse Day. So maybe, Scott, you can give us a little intro to Dykema, and then we can pass it over to Gavin to talk a little bit about the unit that's being represented today and the unit that's going to give us so much insight, no pressure.
Yeah, great. Thanks, Nick. It's always great to be back with you. We appreciate you having us again. We're bringing forth some new unit that have incredible expertise that I think folks are going to find very, very relevant to their practices. So Dykema is a national law firm. We've got about 450 attorneys across the U.S. serving all kinds of client needs. But a large focus of that has been developed over the last couple of years, where we have brought over a number of individuals from the Department of Justice, like myself, my partners, Leah Simonton, Tiffany Egger, Sarah Douglas, and others, as well as kind of focused on that regulatory compliance side of things, and really tried to get the word out about the expertise and experiences that Dykema attorneys have to offer. And that's not only in serving clients, but also providing education and tips and tools like we're going to try to do today, based on those incredible experiences that, one, will try to help people avoid incidents, or two, when they do happen, inevitably, how to deal with them, whether that requires the presence of outside counsel to assist, or whether that's something that enough preparation and execution can help avoid. So awesome. With that, I'll Gavin, please tell them about EIR.
Thanks, Scott. Now you guys all know why I'm so gratified and happy to have Scott here under the Dykema roof. He brings exceptional knowledge and capability to Dykema in our practice. Sorry, that was my phone. I guess what we're here to talk about in the risk and compliance space directly intersects what we're doing currently, which is launching something called the Industrial or Emergency Incident Response Team, EIR team. And I've got to be honest with you, I have toyed around with how to describe the practice. You could start by saying it was an accidental practice, but that doesn't do it justice. It's kind of one that was born out of necessity. What we are finding is I'm a commercial litigator at heart. I got into the industrial accident space early as an associate growing up in the 90s, and that kind of culminated in a trial role in the Deepwater Horizon case. And that introduced me to oil and gas. And guess what? Oil and gas exploration is about physics. Physics applies onshore and offshore. So I use that skill set to start representing some oil field service companies, and here in Texas. And that, the shale fields are all over the place. What we were finding in those cases is that the absolute first engagement a client has post-incident is going to be with OSHA. It's often on the day of, particularly given the severity of it. And so by necessity, we were escorting, if you will, clients through the OSHA investigation process, which is a 6-month statutory process. If nothing happens in 6 months, it's over. But citations can issue, and then that in itself could trigger a contest period and an appeal period. But what we were finding as litigators was it was absolutely essential to get involved at this phase, because what those investigations are doing is identifying and the causes or the root cause of incidents. And given the posture of our clients, some of them could have been, it could have just been a direct employee casualty. It could have been a coworker casualty on a multi-employer work site. They were facing a variety of risk scenarios that necessitated that we understand what OSHA's playbook was. And we found out that when we got involved early, we were directly influencing, for the benefit of our client, the direction of joint investigations, because it was all developing evidence that was to be used in follow-on litigation, primarily in third-party tort actions, where somebody who was not your employee, who was covered by workers' compensation, got injured. And we were finding that even if you were relying on the workers' if you were relying on any type of, defense that you weren't really involved. Oftentimes, depending on the contracting relationship, there were contractual indemnities that basically meant you were being sued because you're going to be pulled into the case anyway to indemnify the actual target. It created a very complex risk picture. And so by necessity, EIR kind of formed over 6 years, and we have been successful at quarterbacking, is what we call it, OSHA engagements. The truth is we have been in 18 area offices around the country and growing as of this weekend. And yesterday I got back from being in the oil field on a new investigation. And we run at the pace of OSHA. So we will show up and quarterback that, and we can talk about all the reasons why we think that's necessary. It's really the core feature of why EIR got stood up. And I think I'm going on talking too long, but what we do is engage with OSHA. We know their playbook. We devise effective solutions, and we have our own playbook that has worked successfully over 6 years. And EIR is just the naming of something that we have already been doing for a long time. And we've done it in the railroad industry, oil and gas industry, construction industry. We even handle things as innocuous as a whistleblower complaint for what's under a doctor's waiting room cabinet, sink cabinet. So it's the breadth of EIR that I think gives it the perspective to be able to speak to clients and to understand their risk picture, because we've probably seen it before, and to marshal them effectively to get back on their feet, depending on what the engagement is. It may be combat, and maybe you need to get something changed legally. But we engage at every level, and with customers who are startups and don't know what a safety culture is, to the most sophisticated multinational corporations who have robust and embedded safety cultures.
Yeah, well, I think what made sense to bring you guys on is because the principles that guide the emergency incident response division, which were perhaps birthed out of oil and gas, do apply. These frameworks and these axioms apply regardless of organization size, regardless of complexity. So maybe, Cooper, I can start with you. What do you think these high-profile catastrophic incidents like Deepwater have to teach compliance professionals who most likely will never, face something that big or at that kind of a scale?
Yeah, I think all of these instances can teach professionals that you don't know what you don't know, and you can be as prepared as you can possibly imagine with every plan, emergency action plans, or whatever it may be. But when the incident actually occurs, your employees, they're going to react just like anyone else would react in a similar situation. It's high stress. And then on top of that, you have OSHA coming in during those situations and questioning your employees and not necessarily informing them of all of their rights. And so I think that is where EIR really comes in. And I think Gavin can probably speak a little bit more to that, but that's a huge component of what we do. We get on the ground early and we help shape that evidence for later on down the road.
Yeah. So as we're kind of setting the stage here, I just want to get down to the fact that, why incident response is really a compliance problem. So when we hear, emergency incident response, what do you think comes to mind? And what do you think compliance folks should be thinking about? Because I think a lot of times we think it's like a legal or a safety function. How do we start to kind of reframe that as a compliance program problem or something that we can add value to? Maybe I can start with you, Gavin, and then we'll go over to Scott.
Yeah, it's interesting. I think I can maybe shed some light on your point by using a recent example. We provided, because we just named this, we did a marketing ad, and I sent you a version of it. The reason it's a version is that same ad, that same marketing material can be rebranded, and we actually have 5 or 6, actually maybe as many as 8 versions, and they all are targeted to very different industries. But what doesn't change is the content, and that content are our life lessons, basically our practice life lessons, and are things that we know. And some of the things that we have learned is the reason this is a different practice is it's a hybrid practice. We're not litigators anymore. We're not regulatory attorneys anymore. We live in between. And all of our customer people, stakeholders that matter, your HSE people, your compliance people, they also live kind of in between. And the thing that is often missing and causing, regardless if it's a Gulf of Mexico oil spill or the more minor but serious injury that occurred in an oil field yesterday, the things that cause those things don't change, and you see commonalities. And if you see that, if you see that from our perspective, we're much more effective at talking to our clients about how they can abate. And it doesn't matter the complexity of the abatement. It has an engineering or a science component. It has a feasibility component. OSHA is only focused on the human, health, the employee safety component, but the client has to look at it from a bunch of different components. And that is unique, not unique to any one client. It's unique to everyone who engages with OSHA or any federal agency, frankly.
Right. What would you add to that, Scott?
Yeah, I mean, everyone's got a plan, right? Hopefully all of your viewers today have a plan. But one of the things that experience has taught us is that you've got to test those plans before an emergency happens. And you've got to be able to identify who those leaders are that are going to step in and kind of lead your response from each component, whether it's HR, whether it's your safety folks, whether it's legal, whether it's a C-suite, right? You've got to battle test your plan on the front end. So one of the things that I think compliance or organizations are great about saying, okay, we want our compliance folks to put together a plan. But when then folks come behind and say, okay, we would like to test it, we want to do a drill. Oh, we don't have time for that. Oh, we don't need to do that. But your plan, you can't be identifying the failures in your plan at the same time you're trying to deal with responding to an emergency that's occurred, right? You want to do that on the front end, identify the gaps in your plan, the failures that are there, revise your plan so that then when you're actually in the throes of the moment and the stresses that are going to be, encircling the organization, your plan is solid. Everyone knows how to execute or what they're supposed to do, their responsibilities are, and you can just deal with the situation at hand as opposed to also dealing with the failures in your compliance plan.
Do you think that's kind of the biggest the biggest or sort of like most dangerous assumption that organizations make about incident response before they have to use it? Like, is that really kind of the root issue? These documentation gaps, we haven't done a tabletop exercise. We haven't trained the kids on how to get out if there's a fire. You know what I'm saying? Like, is that really the biggest thing? Because really what we're talking about is, like, to your point, there's processes, there's procedures, there's policies in place, that are meant to kind of account for these things. And when those end up living as, dead documents, in a bookshelf somewhere, you kind of get this false sense of security that, well, hey, we got a policy in place. Is that kind of the root of it?
Yeah. So that you identify a key aspect of what we have to teach our clients oftentimes. OSHA is a regulatory agency. And so their engagement with OSHA, compliance with OSHA, oftentimes is treated as a checkmark exercise. Or you check a box. We've done our OSHA reporting forms. We've done this. And what we find is there is oftentimes, depending on if it's a large company, if it's a distributed facility company in different states, for example, where you have somebody who's a safety lead, but you've got a facility safety lead as well. That communication is probably the most important in any organization. And it doesn't matter if you're offshore on a rig, and it doesn't matter, or you're doing manufacturing, up in the Northeast. It's that communication is absolutely critical because it's the only way that you can identify threats. It's the only way that you can rectify threats. And the problem is, if no one's communicating, no one's taking ownership, and clients are all good at identifying problems, but often not at identifying practical solutions that are regulatorily permissible. And that's where we can step in. And people look at OSHA as something they just have to get through, when I think the healthier response, and probably over the long term, the least costly response for a company, is to use it as an opportunity to actually take your safety culture seriously. Because at the end of the day, I'd like to think the employer shares OSHA's mission, which is the safety and health of its employees. But that's not to say that ideologically driven OSHA investigations can't run, afoul, basically just be an overreach, and we try to protect against that. So I think that you have to approach OSHA as more than just a checkbox exercise. Understand that they have a mission, and their mission is not counterproductive to being an effective company and healthy company. It's actually better. And I often say, if you give us an hour now with your employees before an incident, I can't even account what it means to have employees already know what an OSHA proceeding is, what their role is in that proceeding before they ever go into an OSHA interview. And trying to teach them that in the shadow or in the minutes after a traumatic event is very, very difficult. So I am an advocate of training upfront because it's not hard and it doesn't take a lot of time. It's not a big cost, and it ultimately saves customers down the line quite a bit.
So, if you're in the audience right now and OSHA is not your biggest risk, just swap out everything he said with DOJ or CMS or whatever your big regulatory body is, because I think all those principles that he talked about kind of apply across the board. And in an incident response, when something goes terribly wrong, kind of to Gavin's point, we don't want that to be the point at which we reveal all the jump ball risk that is really kind of existing inside of the organization. So let's kind of talk first about like the first hours after something goes wrong. Like these first hours, I think, matter more than a lot of us think, kind of to your point. So Cooper, maybe I can start with you. What do you think are the most kind of consequential decisions that an organization might make in the immediate aftermath of some kind of an incident, whether it's a safety violation or something else? And who in the organization do you think is most empowered to make those kind of decisions, or who should, or how can we kind of see around the curve to make sure that power is already within the, is bestowed upon the person that can move the needle the most?
Yeah. I think the first thing is informing the managers on the ground of who the initial point of contact is when there's an incident that occurs. Oftentimes that means immediately getting legal involved. And that should really be your first point of contact. At that point, legal will oversee and make sure that, nothing is being put in writing or investigations that are occurring that shouldn't be occurring, and they're going through the proper channels. I think a lot of times we'll see, we'll be engaged later on in an OSHA engagement after an investigation's already occurred, and you'll see that potentially people put things in writing maybe they shouldn't have, or they would have put it differently if they had contacted legal first. And I think that those are some of the things to really watch out for in the initial aftermath. But in terms of a fatality, OSHA is going to be on site very quickly. And so you're going to want to immediately, for example, get EIR involved or someone on the ground preparing those witnesses, informing the managers of their rights, informing the employees of their rights. Managers, have the right to have counsel present, and it's a great opportunity for EIR or legal counsel to step in and make sure the company's protected. So I think those are some of the most important things in the direct aftermath of an incident.
Hey, you want me
so
to
much
flesh that out of the real world? Sorry.
No, please. It sounds like you're going to say something real world, so I'd love to hear that. Yeah.
So I got back last night. We responded to a well incident down in South Texas yesterday. So it might be helpful to understand the early stages. Just walk through what we did in the first in the first day of that incident. Quarterbacking is important, and this is what that means. The OSHA investigator oftentimes is going to make initial contact, and depending on where you're at and depending on the event, first responders are typically called. And most people don't realize that first responders call OSHA as one of their standard calls that they make when there's an industrial incident. And so oftentimes OSHA will beat you to the scene because they've been told by first responders what they're responding to. That is a chaotic and hectic situation. Oftentimes it's not that situation, but it's important. It illustrates this point. You need to contact the federal investigator, and it doesn't matter if it's Department of Transportation, OSHA. It doesn't matter what the federal agency is, Chemical Safety Board. Tell them who's in charge and let them know that you represent, that you're represented by counsel. And if counsel is doing what they should be doing, they should send a notice of representation because it ethically requires OSHA at that point to make further inquiries through counsel. You need somebody who was doing that so you're not fielding 2-3 different requests from OSHA at the start of an investigation, all while under the trauma of an event. So getting someone involved to slow the process down, to take stock of what happened, to make sure your people are safe and healing, and being given the care that they need. Lawyers are needed for that process, and we have the tools to make that happen and force the coordination that otherwise OSHA is not going to voluntarily give you. And so that's an important thing. And that's what I did all day on Monday. And then I was able, and the reason that's important is this: OSHA would like nothing better than to get to employees during that time before they have been prepared. And remember, if that employee has not been prepared, that employee needs to know what their role is. And they're not to guess any of that stuff. People try to be helpful. They kind of need a witness one-on-one session, and they need to understand that they're not personally liable, and they need to tell the truth, but the truth is what they see, taste, feel, hear, some witness one-on-one stuff. They don't know any of that. And chances are when you're in the oil field, your crews don't know it. And they should know it before an incident happens, not trying to learn it under the duress of an incident. Yet we will get with the employees and prep them.
Yeah, Nick, coming at it from the DOJ and just any agency, right? Because I worked with a bunch of them. DOJ works with investigative agencies and compliance agencies, whether it's CMS or whoever the case may be. One of the things that I think now from this side is speculation is one of the real dangers from employees when they're getting, when something has occurred. It doesn't matter if it's a hacking incident or a billing incident or whatever the case may be. Folks want to provide answers to investigators or agents. They want to, because they think it relays confidence, or it feels like that they should have the answer and they feel bad about that. And so if you have employees who start speculating as to what might have happened, but speak it as fact, well, that's what investigators, agents, or regulatory officials are going to run with. You also have the issue of your C-suite is going to be worried about any public perception, right? And anything that may be blowing up in the media. How do you manage that? How do you control that PR side of things? And you have to make sure that your spokespeople aren't out there speculating as to potential causes or things that might have occurred. All of those things sound simple when we're all sitting here in our offices, right? But when there's a storm surrounding the organization and everyone's in a flurry, someone, like I said, or like Gavin said, that can slow things down for everyone and make sure, okay, we've got a plan, let's execute our plan, and let's go from there. And that's where our compliance officers can really become key in helping make sure that we stay on path.
Exactly. And there was a question kind of to that effect that you just kind of anticipated and answered there, Scott. So I appreciate that. And I just want to say this again. If OSHA is not what you're most concerned about, I think there's a lot of value in hearing some of these war stories and some of these horror stories around those kinds of responses, because they're corollaries for your particular, if something goes wrong, if you have sort of an equivalent type of an incident for your particular business. So John, the one and only John Hughes, how's it going, John? He made a comment in the chat and said, we follow a similar setup for government investigations showing up. We do these kind of dawn raids and have activated it for DHS coming on site. So again, draw these parallels, because many times in sort of an extreme kind of situation, there's a lot of lessons to be learned that do apply kind of regardless of who that regulatory body might be. So what do you, Cooper, you kind of mentioned something about this, and I'd like to come back to you for it. Like, what does the way an incident is initially documented communicate and communicated? Like, how does that end up shaping the regulatory and perhaps litigation exposure that follows? And what kind of steps could a compliance team, again, regardless of their business type, take to kind of anticipate and train people up in some of that 101 thinking that's not going to create, a landmine down the street or, down the road for them?
Yeah, and I think it really goes back to speculation, speculating in documents and in writings. But how it shapes the OSHA investigation overall is you want to come in and you want to be organized and you want to convey cooperation to OSHA. That's one of the factors in terms of when they're going to cite you or how much that penalty is going to be, is your good faith cooperation. And I think it starts with documenting how the incident occurred, going through the proper channels, not speculating, and then organizing that information in a way that is very consumable for OSHA. But the thing about these OSHA citations, which really matters, is that ultimately, whatever you're cited for will be used. It's going to be subject to a FOIA request. If there is any follow-on litigation, those plaintiffs are going to point to that standard and say that's per se negligence, that they breached the standard of care, and it's evidenced by the citation. So it's actually really, really important to shape the evidence and to have a constant line of communication with OSHA. And there's actually opportunities in some area offices. They allow this, and in Cal OSHA, for example, it's actually part of the procedure there. But to brief the compliance officer before any citations are actually issued. And so by organizing the information in that way, you can really affect how the evidence plays out later on down the road in any follow-up litigation.
There's a good question from Divya here. Go ahead, please.
No, I don't want to interrupt the question. Sorry.
Remember, that's my love language. I did say interrupting is fine. Okay.
Well, I'm really good at that, so I'm sorry I haven't done it more. The thing about the internal investigations is this. You should not be deciding without counsel involved whether or not you're going to do one, because they are going to be business records, and if they're business records, they're discoverable. The reality is you should, because you're expected to investigate things that happen and be able to abate them if you identify hazards. The problem is the people that write those reports internally are doing the exact same thing that oftentimes we find are problems with the witnesses that we're trying to prepare, and that is they try to be helpful. And so it's incredibly difficult, especially with engineers and people who are in middle management they want to be recognized as being competent in their jobs. And so they try to fill in the gaps. And oftentimes that's with 80% understanding of facts, not 100%. And they feel like they're letting people down if they say, I don't know, or I don't have enough information. Yet that is a technical requirement of actually writing an incident report. You report the facts. And when you're making corrective actions and things like that, they better be things that you're going to stand behind, because a plaintiff lawyer knows what to do with them.
Classic engineer response. You know what I'm saying? Don't ever tell your engineer neighbor that your lawnmower's not working, okay? Divya had this question. Recent benchmark data suggests that more anonymous reporting and slightly longer average case closure times are coinciding. In the real world incident response, how do you distinguish between healthy investigative rigor and a process that is becoming too slow or losing employee trust? So how would we think about that? Again, it's kind of an intersection or a vector for what we're talking about in the context of a Deepwater Horizon type of issue. But how do we kind of think about that? Maybe, Scott, you can take this one. How do we think about maintaining that kind of balance, right? We don't want to keep stirring the paint. We got to put some paint on the wall, so to speak. But at the same time, we don't want to, we need to move with some kind of speed to maintain that trust and let folks, whether they're kind of internal stakeholders or external stakeholders at a regulator, let's say, let them know that like things are moving forward.
Yeah, I think you used the word balance, and I think that's perfect, right? It is a balancing act, and it's going to depend on the situation and the severity of the situation, right? But I think you're going to want to have some type of not perfect answer or conclusion that you've reached, but at least an educated conclusion, or if it's not even a conclusion, but an estimated response or an educated response as to the information you can provide. But then you also want to caveat that with our investigation or our inquiry is continuing. And if we get that additional information, we're going to supplement and provide that as well. That way they know that, hey, there could be something that changes course. The language that you use in that is also critical. If you speak or write in particular in a way that conveys, this is it, we have our final answers, then that is you're going to be held to that, I guess, down the road, right? But if you speak as, here's what we've learned so far, here's what we're seeing at the moment, these are the things these are still the open issues or answers that we're working to getting, right? So that they understand that this is where you are in the moment, but you still have a number of steps that you're taking. per your plan, right? If you can tie it back to your plan, in accordance with our plan, we've done this thus far. Here's what we understand in the moment. These are steps we have to continue, or we're going to continue to take, and we will come back to you with additional information when we have it. I think it gives you credibility, right? But then it also shows your leadership that you're executing your plan, and that hopefully things aren't going to drag out for years and years on end. It is difficult. At some point, you have to, make a determination of, okay, we're going to close our inquiry in this. But normally, I think the authorities are going to probably provide a lot of guidance is not the right word, because they're not going to tell you, but they're going to tell you when you can close this up and when you can't.
Yeah. And I think, what we're kind of trying to balance between is like, are we going to be clear and transparent, or are we going to be kind of cagey? And I think, to your point, if you have a plan in place that you feel is well vetted, it's been well tested, again, regardless of your industry, it shows that you've obviously thought through something. And I don't think, I think, we've talked about this on other shows, Scott. We have to assume, reasonableness kind of across the board, whether it, especially from the regulator's perspective. These guys are seeing all kinds of incidents across all kinds of companies of all kinds of different sizes. They're not like automatons, you know what I mean? They're not like robots. They understand that, things break and all that kind of stuff. I think if we can show up with a posture of transparency and we can convey that we have a plan in place, and that's like a coherent plan that passes the weight test. If I was ever a professor, I would just be doing the weight test, right? You print out the report. If that weighs enough, then I feel like, okay, there's some thought that went into it. So maybe you don't want to hire me as an adjunct yet. But my point is, like, if we can share like some clarity and convey some, some like coherence about the plans that we have in place, and have that bias towards transparency, I think that turns something that could, be a chess match into something that's a little bit more collaborative.
Yeah. There's you're tying that to something that's actually very important that everyone should know in an OSHA investigation, which is, OSHA has line of sight authority. They don't have to just investigate the cause of an incident. So when you invite them on location, they have the authority to cite you for any observed hazard, documented hazard. So there's this inherent distrust when you're being asked to invite a government agency in, and it feels a lot like kind of spring loading a toy and inviting it into a box. You don't know when it's gonna spring. And I will tell you, in this era of electronic communications, a phone call is really important. And I try to make it a point to call and personally talk to the regulator in charge and establish that open communication. And you would be shocked.
Great point.
How far that goes to resolving things that never needed to become a problem because you're either miscommunicating or your emails are not conveying full intent. You can convey things in person still that you can't do in digital communication, which is now prevalent. And I think that's a really big part of getting somebody involved. And like you said, this is all about preserving the evidence for potential follow-on. And whether or not, there are actually instances where it makes a lot of sense to cooperate and jointly investigate a root cause with OSHA. And there are times that is absolutely not the case. And you get a sense very quickly of whether or not the engagement is kind of an idealistic engagement versus something that's actually trying to remedy a true employee hazard.
And, again,
human engagement. Yeah.
Well, there's a big human element that sometimes gets lost when we're reading about a case that happened or the outcome of something or the guidance that DOJ puts out or OSHA puts out or whatever the regulatory body is. At the end of the day, there's somebody on the other side, a human being on the other side, who's trying to make sense of a situation that they don't have context for. And, it's human experience, right? Like, they're thinking, is this going to be a mess, or is this person going to be, is this organization going to be super cagey, and is this going to be an arm wrestling match, or is this going to be one that goes smoothly? And I think, to your point, that early and often communication can help push you into that good bucket, because people are not continually going to be revisiting this. We need to, remember that there's sort of a behavioral science element to any kind of interaction with a human being, who happens to have a .gov email address. You know what I'm saying?
I think OSHA investigators, because they're human, like you said, I think they make up their mind probably in the first 5 minutes of a direct engagement as to whether or not you're a good actor or a bad actor.
Exactly. It's
And if
instant.
they, and if they think
It's like that book
yeah.
Blink. You know, it's so
Yeah.
much faster than we think.
And I think we would be remiss if we also didn't recognize that in addition, people are motivated differently. A lot of the OSHA experts come out of industrial hygienist space with NASA, for example, or prior military, and they're mission focused and mission oriented. And you can harness that to a client's benefit if you know how to talk to those people. And they're human. And I think whatever you do, you probably need legal advocacy, but make sure you have someone that can talk face to face with somebody, because that's really how understanding happens, I think.
We got a great question in the chat from Carmelo. The question is, the Anti-Money Laundering Act includes a whistleblower retaliation provision enforced through OSHA. In practice, how effective has this mechanism been in protecting individuals who report money laundering? Do any of you guys have any perspective on that question?
On whistleblowers, generally, yes. On money laundering, no. Scott, I don't know if you do.
No, I mean, mine's the same way. Mine's on the whistleblower side, but not in particular to the Anti-Money Laundering Act.
Okay. Well, let's talk about.
It actually raises a good question.
Yeah, it is a good question. So what do you think good looks like in terms of like leadership response in those first 24 hours, whether that's the compliance or legal team or whether it's the organization? What are some of the common missteps that you see? Let's start with you, Gavin, and then we'll go to you, Scott.
I think a lot of the common missteps is they don't gather their employees and have a joint conversation with them once. They need to know the company's behind them, and those employees have never been through this before. And I think how you respond to them oftentimes it determines, depending on the industry, whether they become whistleblowers. And that's an incredibly personal, intimate decision you make with your companies based on the relationship they have with their workforce. I can't, that's pretty basic.
Okay. Scott, anything to add there?
No, I mean, I think that's a great point, and it's probably one that is overlooked. Everybody is so busy running around in a stressful situation, they don't want to stop down and bring everybody together and have a conversation and kind of lay out for them what to expect. You may be asked to sit down for an interview. We will be right there beside you. We will be there to assist. This is how this is going to unfold. We're going to be as transparent and as clear with anyone asking us questions that we can be. But please understand that doesn't mean we're just going to tell them anything and everything that we think, because we need to provide answers that have been tested, as opposed to throwing out possibilities, speculation, and creating bigger problems for ourselves.
So, Cooper, let me pass this over to you, and then Scott, I'd love to hear you weigh in on this. Gavin, of course, it's an open floor for you as well. But like, I want to kind of double down on this, how to engage strategically when there's some outside scrutiny happening, and whether that's with, I would imagine some of these principles are probably the same, whether it's from an internal audit or whether it's from some kind of a regulator. What does it mean to like cooperatively but strategically engage with a regulatory agency or some kind of external body? And where do you think companies or compliance teams or legal teams go wrong? Like, where do they get that balance wrong?
So one of the big things I think would be picking unnecessary battles. You really do need to pick your battles with OSHA. In terms of cooperating with the document requests, for example, some of the requests may be overbroad. Some of it you may know that they don't really need. Oftentimes it's better to just give them what they're asking for. And if it really is such a burden, to I think Gavin's point, call and actually have a conversation with the compliance officer and say, hey, this is really burdensome for X, Y, or Z reason, or we don't have it. And I think that's one of the biggest ways that you can engage in good faith. But it's really just having a constant line of communication and then pushing back where it's actually warranted. There are often times that, for example, during an inspection, OSHA investigators may want to go to areas of the work site that really aren't within the scope of their investigation. And to Gavin's point about OSHA being able to just line of sight cite you for violations, it's really important that you actually narrow that scope and continue to do so. But at the same time, still be cooperative, still be gentle, and I think that those are kind of the key points.
So, Scott,
you want to hear a dirty secret about OSHA document requests?
Please go ahead. What's that?
There's a dirty secret about OSHA document requests. I've been doing this for about 6.5 years, officially. I don't think I've ever once received a formal document request from OSHA. They do almost everything informally. So you're not receiving necessarily subpoenas unless it's a big high-profile case. You're getting document requests by email, and they're just quasi legal enough to be taken seriously. But we advise our clients, you're helping them by responding and treating it as if it's a subpoena, because they can turn around and get a subpoena if they wanted to. So that is a really good opportunity to make an impression and to let OSHA know that you understand their playbook, that you understand that they have needs, that you will be cooperative in that space, and that you're going to join issue where you need to join issue. And that goes a far way towards developing that good faith rapport between regulator and an employer.
What would you add to that, Scott, from the criminal perspective? And maybe you also can respond to this comment that Vicky dropped in the chat. Thanks for this, Vicky. This is great. She said, I was taught long ago to cooperate to the fullest extent possible, but be careful about only answering what is being asked, which is obviously a very tough balance to strike. But what would you add to this from this sort of other perspective, given your background?
Yeah, so I would say, number one, cooperation doesn't mean that you just volunteer anything and everything under the sun. And it kind of ties to that comment or question, right? We teach, or we often advise people that if they're asked what time it is, don't tell them how to build a watch, right? Tell them it's 11:47 a.m., right? You can answer questions and cooperate professionally without trying to make a friend. And I think that's a mistake a lot of people make that then opens up additional vulnerabilities. They try to please them, trying to become friends, right? Which then can lead to additional areas of inquiry that perhaps an agent or an investigator or a regulator hadn't even considered that they needed to delve into. Or it leads to that speculation that I keep coming back to, because I think it's a massive issue in a lot of incident response, right? But it creates so many more vulnerabilities, because folks will often wade into waters that they actually don't have knowledge about, that they're kind of just pulling pieces together and context together, and it just creates a lot of risk for all involved.
Well, yeah, I mean, it's easy to get out over your skis, and then you've said something that kind of opens up a whole can of worms, to your point. So I'm really kind of compelled by this. I think Gavin said it earlier, this sort of like interviewee 101 type training. And that's something that I don't think a lot of us have really thought about. And I don't think that's sort of a common practice. But like, how do you think an organization can better prepare employees or stakeholders for any kind of an incident? We talked about the dawn raids, kind of a play, right? John mentioned that in the chat, some of that kind of role play. What kind of things can we do to help prepare employees for any kind of like regulatory interviews before these kinds of things happen? Where do you see the biggest gaps residing on that front?
That is an awesome question. And quite frankly, it is one of the 3 reasons EIR stood up, because we saw an opportunity to help people get their employees. An employee should be ready for an OSHA engagement, whether they're expecting an accident or not, because by definition, it's an accident. You're not expecting it. And if we have found that if we were able to do in 1 hour, 2 hours with an employee workforce and a presentation on just the essential 101, it saves us weeks of problems post-incident. Because everybody goes into that, one, understanding that we're mindful that there has been an incident. We're mindful that there are outstanding risks that we need to mitigate. But in the end, there's a clear understanding of what everybody's role going forward is. And it is shocking to me how few people know their role in the aftermath of an incident. Even if they may have a title, they don't know the role. And those things, talking to our clients and making sure they've gone through the thought process of imagining hour 1, hour 12, hour 24. That's a conversation you can only have with some people at a company and have them be receptive to it. But it's their job to help everyone that needs to know that message get it through.
there's often these kind of. Go ahead. What'd you say?
No, so I think Scott was talking about this earlier. The biggest message that employees going through this need to receive is that they need to have the process demystified. It's just a conversation where you tell the truth, but they need to be taught and feel comfortable that it is a conversation with precision. And we're not used to talking that way every single day. So it is a way of listening and responding that is counterintuitive, and they need to be instructed on it. And most people are good at it when you identify it. People don't even know they do it.
Doug just said, I've seen many safety programs forget about contractors, permanent or project-based, and visitors. And I've also seen some that are excellent. I had to sit through a 1-hour safety briefing and pass a test before doing an audit. And so, we're kind of talking around this issue. How do we be transparent, collaborative, but professional, not share too much and all that kind of stuff? How do we, I want to talk a little bit about like root cause narratives and like this potential battle that can ensue over what actually happened. So how do you think the story that an organization tells about what caused a particular incident, how can that influence sort of the regulatory outcomes, and who should be responsible for developing and controlling that narrative? And there's kind of a landmine in that question, because perhaps controlling the narrative is the wrong approach. Perhaps that can lead to the sort of hardening of the relationship that can lead to an even worse outcome. So let's kind of talk about maybe all shapes of this question, if we can. We'll start with you, Gavin.
Yeah, so it's a really good question. I think the best way to maybe respond to it is to talk about an incident that happened a couple of years ago, where we had responded to a multi-fatality incident down in Georgia, and it had to do with liquid nitrogen, of all things. And so the fatalities were liquid nitrogen exposure, both contact and respiratory, meaning that they evacuated all the oxygen in the room, so they asphyxiated. OSHA wanted to know what happened. And it ended up being a products liability case because there was a particular feature on the subject equipment that looked like it had not been installed or manufactured properly. But that OSHA investigation also determined that it had been manually, the guard on it had been manually altered so that it made it susceptible to being broken during operations. Now, why do I bring that up? Because that's a big issue in products liability law, where modification by somebody actually is a defense to the claim. And so the OSHA case became a direct focus of a huge team of plaintiff lawyers who were very good. And they were making allegations in the paper. They were making allegations in filings that just simply were not true. And so it is absolutely important, I think, for companies, particularly in these instances, to have a response that is measured, even not a knee-jerk reaction, but acknowledges that if you are still trying to understand the cause at the time of a filing and you don't know it, you should say that and be prepared to say what has happened. Whether you finish your litigation or risk posture is going to go a long way to determining what to actually do in that investigation. But anyway, if that's helpful.
Yeah, no, that is helpful. So Cooper, I want to go to you around this kind of root cause issue, what actually happened kind of situation, or this kind of scenario. If there's like let's say there's a complex issue that involves multiple contractors, vendors, work sites, whatever. How do you think an organization can best protect themselves when that root cause picture isn't clean or clear at the time being? Right. Against in the context of sort of balancing this transparency, this sort of posture of collaboration that we want to go to, with the regulators, so we don't fall into this sort of grudge match with them.
Yeah. I mean, I think regardless, and when you have multiple employers on a single work site, it's going to have a lot of different issues. We deal with a lot of different cases that happen that way. The first thing is kind of these preservation issues. Some evidence is going to be held with certain entities on the work site. You're going to have some evidence. So there's naturally going to be some cooperation between your client, your company, in other companies. But I would still be careful about what you're saying to those other companies. Oftentimes, these OSHA engagements do sort of turn into battles. I mean, one company will be pointing to the other company and telling the compliance officer, well, it was their fault, or they were controlling this area, when in actuality, that's not the case. So you do want to be careful what you're saying to other companies. You still want to engage with OSHA respectfully and cooperatively, and those companies respectfully and cooperatively. But I wouldn't just cooperate with them to the same extent that you're cooperating with OSHA.
That's good. That's
I think one of the things you can do, Nick, on a lot of with any regulators, agents, investigators, whatever the case may be, you can try to help steer or persuade that maybe there are things that they're not considering that you think might actually help in your client's narrative, right? And one of the ways that you can be effective in doing that is just asking questions, knowing you're not going to get answers. These folks are not going to give you answers. It's their job to not give you answers mid-investigation. But ask questions. Have you considered the possibility that X could have been a factor? Have you all looked at this yet? Have you, things along those lines, where you're not trying to tell them what the narrative is, but these are considerations that that you've got in your mind, right? That may have affected the entire situation, that you want to make sure that they are at least, keep it in the back of their mind that they should look at before they reach any conclusions.
So on that, as we kind of get to kind of wrapping up here, maybe I'll start with you on this one, Scott, and then maybe I'll go to Gavin. What role do you think a compliance officer or compliance professional should play in guiding internal reviews and root cause analyses? And I'm asking this kind of particularly in the context of when findings may be used against the organization. Is that a strictly legal thing? Is that a strictly a
I think
outside
they have
counsel
to be
thing?
a process, help try to be a process control.
Please. Oh, you just cut out, Scott. What were you going to say?
Sorry, I was experiencing a delay there, so maybe I'm caught up now. I don't think it's strictly legal, but I do think the outside counsel needs to play a large role. But I think on the compliance side, the compliance officer can be a procedural assist, right, in helping guide the right people into the conversation, so that root cause analysis can be determined by the folks who have the knowledge that spans all aspects of the organization, and not just one individual making a call kind of at the ground level, right? We want to make sure the right people are in that conversation, that the conclusion is reached as a collective for the organization, and not one person's opinion or conclusion, all of a sudden binding the organization to a position going forward.
Well, yeah, and I think to that point, that kind of underscores the importance of compliance being in the room, and compliance having done the work kind of beforehand, both to gain the right knowledge about, the business, right, and have that correct context, and have the right frameworks that can be applied when an emergency or when an incident pops up. We have a unique vantage point in compliance. We have a unique perspective on the business, and we have a unique perspective around overall risk mitigation in the context of the regulations that our company needs to kind of conform to. So we must be able to add that, very specialized skill set when the business needs it most. So as we're wrapping up here, I want to do a lightning round. Not that fast of lightning, okay? But I just want to talk about what do you think is one thing that a compliance professional who's here today can do in, regardless of where their program is from a maturity perspective, or where they are, or which regulatory bodies they intersect with most. What's one thing that a compliance professional can do today to better improve their organization's incident response posture? Let's start with you, Gavin, then we'll go to Scott and wrap up with Cooper.
Okay. I think the absolute best thing they can do is try to assess and understand the level of their employee workforce, and ask themselves this question. If an incident happened tomorrow, I don't know your industry, I don't know your operations yet, but have you gone through the mental exercise of what you're going to do, who is involved? If you have not mentally gone through that exercise, do it. Because you will identify your own deficiencies. Call us, we can help you. that's what I'd say. I would say that the other thing that a really good compliance officer does is most companies are very good about getting lessons learned established. There's Taproot and all sorts of other programs and initiatives in order to identify root cause and causation. What I think a really good compliance officer does, and the ones that I've appreciated really working with, are the ones that then take that lesson learned and know what to do with it. And that's hard because it is is specific to, it is as specific as the personality of a company, right? And its executives. But that literally, somebody needs to be a safety culture champion. And when a lesson's been learned, it shouldn't be forgotten. It actually ought to be implemented. And that is the difference between, I think, an employer that cares and an employer that is just treating an OSHA engagement and its regulations as a checkbox exercise.
I think that's a great point. That's almost like the last mile. You can have all this head knowledge, but if you can't bring that into the world and actually do something with it, then it's just going to kind of fall flat and it's really kind of worthless. What would you add to that, Scott?
I agree.
If you haven't tested your plan, whether it's some type of tabletop exercise or something like that, start advocating for it right away.
And you I think can start to do that in little ways. I think Alcoa is this famous example from a safety perspective. And for my, I kind of grew up in manufacturing, but as I've gotten into this industry, I've seen, kind of an analogy or kind of sort of a corollary. The best run manufacturing companies are ones that bring sort of safety top of mind. They're talking about it all the time. They're starting every meeting talking about safety. I think the most de-risked organizations that sort of outside of manufacturing are talking about, the culture of compliance and an ethical culture and speak up culture and all those kinds of things consistently, as opposed to, once per year. And there was a great idea in the chat to kind of pepper some of these principles that we're talking about, whether it's, interviewee 101 or the fact that we are going to have a posture should something go wrong of transparency and collaboration with any regulators that come in here, can do a lot to kind of mimic or replicate that kind of safety impact that Alcoa had on their bottom line and overall, success of the company. All right, Cooper, bring us home. What do you think is the one thing that folks can do today?
I would say enforcement. So you can have the policy, but you need to make sure you know that it's being enforced, and there's ways to audit the actual enforcement. Most incidents that I've seen occur because the policy was there, it just wasn't being enforced. So to me, that's the biggest thing.
Awesome. All right, well, let's get one more massive emoji explosion for the Dykema team. Guys, thank you so much for coming in and sharing these insights. It was really interesting for me. I'm not an OSHA expert, but it was interesting to see so many kind of through lines and comparison points between some of the other conversations that we've had about DOJ response or Department of Health, DHS response, things like that. There's a lot of these same sort of underlying foundational principles that entail us documenting things properly, us thinking through our plan, stress testing those plans to make sure that people know what they should do and where things could go wrong. We're always striving for perfection, maybe disproportionately in this industry. And while we know that perfection is never going to be attainable, it's noble to pursue it. And that takes a kind of a forward pressure of continuous improvement and asking questions that perhaps we haven't asked before. So this was extremely insightful. Really enjoyed you guys having you guys on, and we will see you next week. We got a bunch of phenomenal episodes. Big launch for the Ethical Nightmare Challenge with our good friend Reed Blackman, and then we're diving deep and answering all of your questions from the benchmark report session. So you're not going to want to miss either of those. We'll see you guys next week.